I had another case that I wanted to talk about, and it had to do with a standard of review. And trial attorneys are familiar with the three common standards of review: substantial evidence, abuse of discretion, and de novo. But I wonder, Jeff, if you had ever heard, or Fran, have you ever heard of the standard of review known as the finding compelled as a matter of law standard of review?
No.
No, you guys always scare me. You come up with this stuff that I've never even heard of.
It's Tim. Blame Tim for your lack of sleep.
That's what I live for. So the case is King versus May Wesley. It's a non-published case, but the plaintiff there was the holder of a $12 million judgment against the defendant, judgment debtor, and alleged that the debtor had engaged in fraudulent transfers of his wealth. The trial court entered a judgment for the debtor, finding the plaintiff failed to adduce any evidence of fraudulent intent. But so this was a judgment for the defense, and the plaintiff took this up on appeal. Typically, plaintiffs don't take a case up on appeal because you failed to persuade the finder of fact. You can't argue the substantial evidence standard of review applies and see, I adduced some substantial evidence. You were obliged to give me a judgment in my favor once I offer substantial evidence. No, that's not how it works. The plaintiff can only get relief if the plaintiff can show on appeal that the evidence the plaintiff offered was so overwhelming and not contradicted at all by the defendant that a judgment in plaintiff's favor was compelled as a matter of law. So that's the finding compelled as a matter of law standard of review.